Judge Stark, what a career. You've served for 10 or 11 years as district court judge, first starting as magistrate, I might add, and then as district court judge and chief judge, and now aspiring to this new level, this appointment. You joined with two other former law clerks in a tribute to Judge Walter Stapleton in the Delaware Law Review, focusing on his judicial philosophy, and of course, he played a key role in one of the landmark cases, which is remembered today especially. Would you like to comment on why you thought that judge deserved special recognition?
Well, thank you very much for the question, Chairman Durbin. It was the best possible way to start my career to clerk for Judge Stapleton on the Third Circuit Court of Appeals. He taught me and all of his law clerks the importance of carefully understanding the binding precedents of the Supreme Court, and in his case, the Third Circuit, and working as hard as possible to understand the record that was before us and applying those precedents to the record before us and keeping very focused on only the issues that were presented to the court and to writing with clarity to try to give guidance to the district courts.
You said in the article that you co-wrote, Judge Stapleton does not, however, read text in isolation, and thus is not a textualist in the narrow sense identified by some, perhaps referring then to Judge Scalia. In both statutory and contractual cases, he reads text contextually, and where there is ambiguity in light of the relevant relevant legislative or bargaining history. Would you like to expound on that a moment?
Well, thank you, Senator. In handling more than 6,000 cases over my time as a federal judge and having written more than 2,000 opinions, it's quite frequent that I'm asked to interpret the constitutional provision or statutory provision. I always follow the same process. I start with the text. If the text is unambiguous and it answers the question, that is the end of the analysis. If there is ambiguity, I then look to binding precedent from the Supreme Court and from the Court of Appeals. If that still does not answer the question, I will look to other circuits that are not binding on me and even to persuasive opinions from district court judges. If all of that does not answer the question, then I will turn to other canons of statutory construction, and that could include consideration of legislative history. So that's the process I follow, and I would follow the same process if fortunate enough to be confirmed to the Court of Appeals.
And occasionally a reference to a recording artist?
Thank you, Senator, for that question. I'm not sure that I've made any reference to recording artists in any of my writings, at least my writings as a judge.
Ms. Garrity, when I read your biography, I realized that you clerked for Judge James Zagel in Chicago, and it brought back a flood of memories because I was the staff assistant to the State Senate Judiciary Committee in Springfield, and Jim Zagel used to appear before that committee regularly as a prosecutor. So we go back a long, long way. I'm sure that was an interesting experience in your own legal career. And I've noted that you've received letters of recommendation from a number of people suggesting you're the right person for the federal court, and most notably many who were on the opposite side of litigation that you were engaged in. And I think that speaks well of you, that they respected you even though you were adversaries in a courtroom. You made a specialty of representing individuals who were incarcerated for their inability to pay a fine or a fee, something you've referred to, some others have referred to as modern-day debtor's prison. In the year 2020, a prominent legal publication in Georgia, the Fulton County Daily Journal, named you the Attorney of the Year, in large part for this work. In your experience, what are some of the negative consequences, both to the individuals and to America, from the practice of incarcerating people because they're poor?
Thank you for the question. First, I would say that the Supreme Court has said that there can be no equal justice under law when the kind of trial a person gets depends on the amount of money that they have. Throughout my career as an advocate, I have tried to enforce the Constitution and the rule of law on behalf of indigent defendants, and as an advocate have been critical of incarceration for debt under circumstances that do not comply with the Supreme Court's directions in that area.
Thank you for that. I'm going to go to Mr. Ho and make reference to a gentleman who came here to say nice things about you, Chuck Schumer. He said you've had extraordinary success as an advocate, and the record speaks for itself. You've spent most of your career fighting for the civil rights and liberties of other Americans, all Americans. In particular, you defended the right to vote and recently the right to be counted accurately in the census. And you've litigated at the trial and appellate level, including appearances before the United States Supreme Court. I also understand that you've used social media during the time that you've served as advocate, and exercising your First Amendment rights, you've commented on a number of topics. Now you've been nominated to set aside your advocacy, your life's work, and to tell us that you can be a federal judge and that we can trust you to know the difference between serving as an advocate and a judge. Why should we?
Thank you for that question, Chairman Durbin, and for giving me the opportunity to address this issue. I very much understand that my current role as an advocate is different, very different from the role that I've been nominated for, and that, like every judge, I have to set aside my past advocacy work, the work that I've done consistent with my ethical responsibilities of zealous advocacy on behalf of my clients, to serving as a fair, neutral, impartial arbiter of the law. Now, with respect to social media, I want to say to members of this committee that I very much regret the tone that I have taken on social media from time to time, particularly if it's given anyone the impression that I wouldn't be impartial. As in my role as an advocate, have taken a role on social media. It's been a part of my job. I've pushed the envelope to break through, but I regret the times that I've crossed the line with overheated rhetoric. It doesn't reflect who I am. It doesn't reflect how I've shown up in court or how I've conducted myself in professional settings. I'm deeply committed to the principle of equal justice under the law, and if confirmed, I'll do everything I can to ensure that everyone who comes before the court gets a fair shake, a fair opportunity to be heard, and ultimately equal treatment under the law.
It's been noted already that your family background plays an important role in your values. Would you like to speak to that for a moment?
Sure, and again, I appreciate the opportunity to talk about that, Chairman Durbin. My mother's father, I never had the opportunity to meet him. He served in World War II in the United States Armed Forces of the Far East in the Philippines. He died at a young age. My mother was sent to the United States to live with her aunt who adopted her, a woman I knew as my grandmother, and she instilled in me the values of hard work, love for family, that I've tried to carry throughout my life and throughout my career.
Thank you.